A new law is shaking up the business world, changing how almost all U.S. businesses operate forever. This law aims to get rid of money laundering, terrorist financing, and other illicit activities. Sounds good, right? But here's the catch. It's going to require almost every business to disclose sensitive information about its owners through what's called a beneficial ownership report. And if you don't comply, well, you could face hefty fines or even jail time. I've spent weeks reviewing the law and its history and preparing a compliance plan for my clients. And in this video, I'll show you the who, what, why, when, where, and how of the law, including deadlines and penalties, and the 3 ways this will affect how you operate your business going forward. So you'll have a clear understanding of how to fully comply and avoid fines and even jail time. Currently, there are over 2 million companies formed in the US each year, and no state requires companies to disclose certain information about their owners. A person forming companies typically provides less information at the time of incorporation than needed to obtain a bank account or a driver's license. Well, let's let Congress explain.
Okay, the Rules Committee will come to order. Shell companies today often operate in the shadows. They take advantage of loopholes in current law to make illicit profits and conduct illegal activities, all while hiding their true donors. Bad actors have used this reality to go on a global crime spree, funding terrorists and even going as so far as to circumvent U.S. sanctions on countries like North Korea and Russia. The bill we're considering today, H.R. 2513, will close these loopholes and give law enforcement the tools they need to crack down on this crime.
A lot of anonymous shell companies are funds or conduct financial transactions, enabling criminals, terrorists, and money launderers to make use of them to hide their illicit proceeds and facilitate illegal activities. This lack of transparency is considered by law enforcement and financial institutions to be a primary obstacle tackling financial crime and terrorist activities. The U.S. doesn't even meet international standards with regards to disclosure of beneficial ownership. This new law, Corporate Transparency Act, or CTA for short, addresses this concern by requiring companies' beneficial owners to be disclosed to the Financial Crimes Enforcement Network, or FinCEN for short. The CTA will also stop money laundering by making it easier to trace illicit funds and prosecute offenders that are protecting national security interests, as money laundering often funds terrorist activities, aiming to restore the trust and stability in the U.S. economic system, making it easier for global cooperation in combating financial crimes, increasing public trust in businesses, which is beneficial for the economy as a whole, and protecting legitimate businesses from being associated with financial crimes. Before I discuss whether this law applies to your legitimate business, I need you to hit that subscribe button. If you want to learn legal strategies to grow your business and avoid lawsuits, I upload videos every week. So who does this law apply to? If your business is a privately held LLC or corporation, either domestic or foreign, and registered to do business in the US, you're what's called a reporting company under the CTA, and you'll need to disclose information at FinCEN. Detailed and sensitive information I discuss shortly. Some companies are exempt and not considered reporting companies at all, such as banks, nonprofits, publicly traded companies, public utilities, large private companies that employ more than 20 full-time employees in the US with more than 5 million in gross sales and have an operating presence in the US, and subsidiaries of the exempt entities, and also any inactive entity that was in existence on or before January 1st, 2020, is not engaged in an active business, is not owned by a foreign person, whether directly or indirectly, and has not experienced any change in ownership in the preceding 12-month period, has not sent or received any funds in an amount greater than $1,000 in the preceding 12-month period, and does not otherwise hold any kind or type of assets anywhere. So what does the CTA require to be disclosed? The CTA requires reporting companies to disclose who the beneficial owners are, certain information about the owners, and information about the company. Beneficial owners are individuals who either have substantial control over the company or own at least 25% of it. And if you're worried about your private information being out there, stay tuned until the end, where I'll discuss who can access that information. For substantial control, think senior officers, authority over or substantial influence over important matters of a reporting company. For the 25% ownership requirement, it is someone who owns or controls directly or indirectly not less than 25% of the ownership interest of the entity. Lenders could be considered if they enable the holder or exercise the same rights as one of the ownership interests, including the ability to convert the instrument into the ordinary ownership interest. What is not a beneficial owner, however, is a minor child, an individual acting as a nominee or agent or on behalf of another individual, an individual acting solely as an employee of the reporting person, an individual whose only interest in reporting in a reporting company is through a right of inheritance or a creditor of a reporting person unless the creditor meets the requirements of a beneficial owner. Reporting companies must also report the following information for each beneficial owner and each company. So what information has to be reported for each beneficial owner and each company? Well, full legal name, date of birth, current as of the date on which the report is delivered, address, the unique identifying number from an acceptable identification document like a state-issued ID or a FinCEN identifier issued in accordance with the CTA, and image of the identification document, such as your license. A reporting company must also report the following information about the reporting company: the legal name or any trade names, address of the principal place of business, can't be a PO box or office of formation registered agent, state, country of formation, and EIN. I know what you're thinking. That's a lot of private information. Will all this be public? I'll talk about that shortly. Well, how do you file? FinCEN is developing a beneficial ownership secure system, or what they call BOSS for short, where the reports will be submitted electronically. FinCEN intends the additional regulations governing who may access the information and what safeguards will be required to ensure that the information is secured and protected. FinCEN will also publish reporting forms and guidance and documents that companies will use to comply with their obligations under the CTA. Because it's secure, the only organizations that can access the information reported to FinCEN are federal agencies engaged in national security or in law enforcement, financial institutions subject to CDD rules, and Treasury Department and other regulatory agencies. Well, when do you file this? For any reporting company that has been formed or registered before January 1st, 2024, the beneficial ownership report must be filed before January 1st, 2025. For any reporting company formed or registered after January 2024, not later than 30 days after formation. There's also an updating requirement. Reporting companies must update changes in beneficial ownership not later than 30 days after it changed. What if you don't file? Well, more importantly, what are the penalties for not filing? Fines up to $500 each day, capped at $10,000, and possible imprisonment of up to 2 years for any person who willfully provides or attempts to provide false or fraudulent beneficial information, fails to report complete or updated beneficial ownership information to FinCEN. Well, what's next? Here's how I'm telling my clients to prepare. Start collecting the information required of your disclose now in order to be best prepared to comply with the reporting disclosure obligations of the CTA. Update company governing documents to include a representation by each shareholder, member, or other owner that they will comply with the CTA. An indemnification agreement by each shareholder, member, or other owner as applicable to the company and its other shareholders, members, or partners that such parties' failure to comply with the CTA will indemnify the company for any loss, or for such parties' false information provided. And a consent by each disclosing party for the company to disclose identifying information regarding such party to the FinCEN. Also, I'd recommend creating a system to track any changes in the company and the reporting company to make sure that anything that needs to be updated with FinCEN regarding CTA will be provided immediately. Well, what does this mean going forward? First, it may discourage forming multiple companies and having fewer rather than many to avoid an administrative nightmare. This could affect how lawyers and accountants advise structuring businesses going forward. Second, if considering purchasing a company, add the CTA compliance of the checklist of items to investigate. Third, it's another step businesses must follow to ensure that they reap the benefits of the LLC on top of all of the other many necessary steps, which I discuss in this video here.